Hello students, my name is Sunita Sridharan. I am a lawyer and a patent agent. I am also the founder and the CEO of SKS Law Associates, which is a law practice handling patent work which is based in New Delhi. Today I am going to handle module number 28, which is relating to patent rights and the limited exceptions therein. The entire focus of this module and this session would be to look at what are the patent rights and what are the exceptions to the patent right. As you are aware, the patent owner is granted a patent right by the government of a country in which he has filed the patent application after due prosecution. This patent right gives him the right to exclude third parties from using his invention. This invention may be a product or it may be relating to a process. You are also aware from your previous modules that patent right is enshrined in Section 48 of the Patents Act. But you will also be aware that Section 48 is subject to the previous Section 47, and it says very clearly that subject to the exceptions in Section 47, the patent right is granted. In this presentation, I will touch very briefly on the patents, the patentability requirements, non-patentable subject matter, and the exceptions to patent right. The exceptions are experimental or scientific use exception, foreign vessels exception, public non-commercial use exception, regulatory use exception, prior use exception, exhaustion of patent rights exception. Now, to come back to the brief background on patents and its significance, you are aware that a patent right is owned by the patent owner, and a patent owner can be the inventor himself or any person to whom the inventor has assigned his rights in the invention. So, the patent owner can be a company also by way of an assignment. The patent owner can also be the heir of the inventor or the person who is assigning his rights, and this is by way of operation of law. For instance, in case a will has been written. The patent grants a right to the patentee for a period of 20 years. That is how it is in India and in most of the countries around the world. Now, in these 20 years, he has a right to exclude others from working the patented invention without his express permission. Now, you would have heard about PCT applications. In case of a PCT application, that is the Patent Cooperation Treaty, and applications filed thereunder, the patent term for a national phase application is the date on which the international application was filed. And in case of Paris Convention, it is from the date on the first priority. Now, just to touch briefly on the rights that the patent owner has under Section 48, it says the rights are territorial in nature. The rights are subject to exceptions laid out in Patents Act, especially Section 47. And in case where the invention is a product, the Section 48 very clearly states that the patentee of a product patent has the exclusive right to prevent unauthorized third parties from making, using, offering for sale, selling, or importing for those purposes the product into India. In case of process patents, the patentee can stop a third party from the act of using, offering for sale, selling, or importing for those purposes the product obtained directly by that process into India. Now, having looked at the rights, let's just quickly look at the significance before we go on to the exceptions and find out why those exceptions are significant too and why they have been enshrined into the law. The patent has certain significance. For instance, it is seen as an award to the inventor for inventing something and for contributing to the technological advancement of society, because every patent application which has been filed gets published in 18 months' time and comes into public domain for people to access, to study, to read, and to build upon. However, for the entire term of patent, where as long as the patent is in force, a third party cannot use the invention. He can read about them, but he cannot use the invention commercially without the express permission of the patent holder. And as you know, this is for a period of 20 years. Now, what are the exceptions? We have looked at a number of exceptions when we started the session and we listed them out. Now, we shall go into each one of them very briefly. You can read about it in greater detail in the module, in the written module, and you can also read up on the different case laws as and when they come up in the courts or when you are going through the case laws or the various journals. But for the purposes of this presentation, we will try to understand what are these exceptions and why are they there, and the significance that they have on the patent owner and the society at large. Now, to talk about the section 47 exception, which is very clearly enshrined in the section which deals with the rights of the patentee. It says that the use by government for own use is exempted. That means the government can use any machine, any process, or any drugs or pharmaceutical or medicines which are patented or which are pending patent application. It can use them for the own use. That means the government cannot commercialize, but it can use for public, non-commercial use. And these are enshrined in section 47(1), section 47(2), and in section 47(4). We also have a very interesting exception which very few countries in the world have, and this is known as the experimental or the research exception. Please do not confuse this with the Bolar exception, which is very different. That we shall deal with in a little while. The research or the experimental exception clearly states that if you are using the invention, the patented product, the patented process for any experimental work or for teaching or for use in a laboratory without any commercialization, then the patent owner cannot bring a charge of infringement. Therefore, it means that any of the universities, any research lab can use any of the patented invention which has been patented in India. You must remember that the Patent Act 1970 and the rules apply only to the territorial jurisdiction of India. So, if the patent has been registered in India, then the patent owner cannot bring an action of infringement where that particular patented invention is used in a university or is used by a research lab, even if the research lab belongs to a company which is otherwise commercially engaged in commercial activities. The section 47(3) is a research exemption which is crucial for R&D, that is research and development, and can be used very effectively. And it is very surprising that very few people are aware of this provision. Unfortunately, this provision of section 47(3) is often confused with Bolar exemption, and therefore the confusion arises both amongst the people as well as with the courts during arguments in different cases, and this leads to major confusion. Now, another exemption which is in a succeeding section after section 48, which enshrines the patent rights, talks about exceptions on patents which are used in foreign vessels. I am talking about section 49. Section 49 states that if any patented invention is used on a foreign vessel or an aircraft which is temporarily or accidentally in India or in the Indian territorial waters or in the Indian airspace, shall not amount to infringement, and no action of infringement shall lie against the owner of that particular vessel or aircraft. Which means that if there is an aircraft which has any kind of product which is on the aircraft, which is fixed on the aircraft, and it is landed in India and it's on the Indian airport, and they have not taken permission from the patent owner who owns the right in India, it will not be considered to be an infringement because it is there temporarily and it is there accidentally. The same logic applies to vessels, that is ships, boats which are there on the Indian territorial waters. This also means, very briefly to talk about registration, because by way of evidence the courts would want to look where was that vessel registered. If that vessel has been registered abroad, all is clear. If that particular vessel or vehicle or aircraft has been registered in India, then the question is, where is this use? Where is it going to be used? If it is ordinarily used in a place outside of India, and it is only accidentally in India or the Indian territorial waters or in the Indian airspace, it shall not amount to infringement. Now we shall come to the very important Bolar exemption, the one which is normally confused with the research exemption. The Bolar exemption is a term which comes from one of the US case laws, Roche versus Bolar. The whole idea behind this case, or the reason why this case was filed, is the inequitable time extension which has been given to a patent owner beyond the term of the patent. Now let me explain this very briefly. In many areas of technology, that particular patented product cannot be marketed unless it receives regulatory approvals for marketing from a regulatory authority. One very good example of this is drugs, medicines, medical devices, and even insecticides and fertilizers. They are required to be approved by the regulatory authority. In case of drugs, it would be the regulatory authority under the Drugs and Cosmetics Act. In case of insecticides, it is by the registrar who would then give the approval. That means even if the patent has been granted on the invention, it cannot be commercialized unless it has received approval from the regulatory authority. Now, this dual process means that the protection on paper is from the date on which the patent application was filed, but the protection in the market would be from the date where it has been granted. You are aware that under the prevailing Patent Act, the day the patent is granted, it is deemed to have, you have the rights from the date it has been published. That is an 18-month publication. Now, in this scenario, a third party who is waiting for this patent to expire, that means the patent rights to expire, and he is waiting to bring in equivalent products into the market, which we often call generics, but other non-patented products into the market. He cannot do anything about it till after the patent has expired, because if he has to manufacture it for purposes of submitting data for regulatory approval, he cannot do so because that may be deemed to be an infringement. He cannot take refuge under experimental exemption or research exemption because it is not research. What he is doing is he is manufacturing that particular product for purposes of submitting data to regulatory approval, for regulatory approval to the regulatory authority, so that he can get the marketing approval for commercializing. Therefore, whatever work that he does during the term of the patent would be deemed to be for purposes of commercialization. In such a situation, it would be very inequitable that when the patent term expires after 20 years, the patent owner continues to have an extended period of exclusivity, because it is only after the patent has expired can a third party work that particular patent, prepare his own equivalent drugs or medicines or pharmaceuticals, submit it for regulatory approval. And this enjoyment of this extra time is something which is inequitable, like I said earlier. And this was the main crux of the Roche versus Bollard case. While Bollard lost this case, eventually, there was a bill which was passed, the Hatch-Waxman bill, and this was approved by the US Congress, and finally it came into law, which said that there would be an exemption if the person is working any kind of patent for purposes of submitting for regulatory approval. The same thing has been enshrined in the Patent Act of 1970 by the Indian government, where we very clearly say that, if I may just read, this is section 107A. Any act of making, constructing, using, selling or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being in force in India or in a country other than India that regulates the manufacture, construction, use, sale or import of any product does not amount to an infringement of patent right of the patent owner. This is really interesting. This is interesting also from the point of what is known as para 6 of the Doha Declaration. Many of you may be aware, and I am digressing a bit from this point, but the significance of section 107A, subsection A, is very clear, and it is a very progressive section and is extremely significant. Many of you are aware that in 2001, there was the WTO round of discussions, and in which they adopted para 6 of the Doha Declaration, which says that if there is an emergency or extreme urgency in a country and they declare it to be so, or if that particular country does not have a patent regime, and they require a set of medicines, then any other country where there is a patent regime and a patent in force on that required medicine can export that medicine to this particular country which requires it, and it shall not be seen as an infringement. Now, this is, as you are aware, as part of a declaration, and there are many countries which are members of the WTO who are part of this, and to be able to enforce it by way of law, it has to be statutorily ingrained, or it has to be enshrined in the law, and that has been enshrined in our law under section 92A. Now, when a person under section 92A wishes to market, that is export a medicine to another country which requires it, then in such a case there are two things that needs to be taken into account. The first, the country which requires it must have declared that there is a requirement for the particular drug, and second, if there is a patent on such a drug in India, then the person who wants and person here also means a company, can go to the Controller General and he can declare that he would like to market this, and he files, he goes and he can prepare this and he can sell it or export it out of the country without any fear of a suit of infringement filed against him by the patent owner. Indeed, if a suit for infringement has been filed, he can approach the court with this evidence, and that itself will be a defense, a very valid defense against infringement. Now, in such a situation, for a person to export, and remember section 92A is only limited to drugs and pharmaceuticals, it is not for any other patented product. So, for a person to be able to export it to another country during the term of the patent, or for a person to approach the regulatory authority for purposes of marketing approval, he requires that data. He can prepare this under section 107 subs A, that is section 107A subsection A, without any fear of infringement. So, therefore, this is an extremely very significant and very progressive piece of legislation which has been incorporated. This was done under the Patents Amendment Act of 2002, which came into force on 20th of May 2003. So, this provision provides a statutory right to manufacturer to use the patented invention to develop and submit information required for obtaining regulatory approvals anywhere in the world, including India, without the consent of the patentee. This is especially useful for generic drug manufacturers, manufacturers of pesticides, fertilizers, medical devices which require regulatory approvals for marketing the product. Then I had flagged prior use exception. What exactly does prior use exception mean? Very few really understand this, and in fact, as far as I know, it has not really been applied yet. If you come across a case law in which this has been applied by the courts, it will be very good if you share it back with the entire team. Now, to talk about the prior use exception. How does it sound when I say that if I have been using a patented product which is patented now, but I have been using it much more longer, much before it was even filed, even before it was patented, I have been using it for that time since then, and therefore I should be allowed to continue to use. Do you think it makes any sense under the Patent Act? is it logical? Normally, it would not be deemed logical due to two reasons. One, novelty is one of the main criteria of patentability. And if somebody has been using an invention even before it was filed or before it was granted, it cannot logically be done. And second is to do with the fact that once a person has gotten a patent right granted to him by the patent office, then he is deemed to have the rights from the date it was first published in India. So, how does this work out? This works out due to what is known as the historical precedents that we have built into the Indian Patent Act. Many of you are aware that based on Justice Iyengar Committee report, when an newly independent India set about revamping its Patents Act, it came up with an act which said very clearly that only process patents will be granted for pharmaceuticals, medicines, chemicals, food. Product patents will not be granted. This was the law which is known as the 1970 Patents Act, which came into force in 1972. For almost 30 years, this is what happened and went on. But once we became members of the TRIPS agreement, the trade-related aspects of intellectual property rights agreement under the WTO, we had to, under Article 27, grant patents in all fields of technology, and we had to grant product as well as process patents. One of the provisions under the TRIPS agreement said that if it was a developing country, then they would get time to implement this provision. It also said that if you do not have a provision for granting product patents in all areas of technology, then you will get time. So, this two time put together gave India, a developing country at that time, 10 years in which to implement the Article 27 of the TRIPS agreement. And this meant that there were transitional arrangements made, and transitional arrangements in this case were the mailbox applications. So, for product patent applications for products were filed in India, and that was allowed under the 1999 amendments, and they were put into a mailbox to be opened only in the year 2005 for purposes of examination and grant of patent. So, Section 11A(7) has certain provisos. In all, there are 3 provisos, and they are very interesting provisos. The proviso 1 states that provided that the rights of a patentee in respect of applications made under subsection 2 of section 5 before the first day of January 2005 shall accrue from the date of grant of the patent, not from the date of the publication, but from the date of the grant of the patent. And section 5(2) relates to the very peculiar section that we had under the original Patents Act of 1970, which granted only process patents to drugs, pharmaceuticals, medicines and food and chemicals. The provision, the proviso to section 11A(7), the third proviso, is even more interesting. It says that provided also that after the patent is granted in respect of applications made under subsection 2 of section 5, the patent holder shall only be entitled to receive reasonable royalty from all such enterprises which have made significant investments and were producing and marketing the concerned product prior to the first day of January 2005, and which shall continue to manufacture the product covered by the patent on the date of grant of the patent, and no infringement proceedings shall be instituted against such enterprises. Very interesting. So this particular proviso to section 11A7 states that if I was manufacturing a drug on which a patent application had been filed under section 5(2), and I had set up factories to manufacture this before the first day of January 2005, then even after the patent is granted to the rightful patent owner, he cannot bring a case of infringement against me. Instead, I would have to pay him reasonable royalties, and I can continue with the right to work that particular invention. The last one is exhaustion of patent rights, and this is enshrined in section 107A(b). This was also introduced in the Patents Amendment Act of 2002, and it very clearly said that if you import patented product and any person imports it from a person who is duly authorized under the law to produce and sell or distribute the product, it shall not be considered as an infringement of patent right. Why does it say so? Because there is something known as the principle, the doctrine of exhaustion, or the first sale doctrine. The rationale is that when a patent holder has already reaped the benefits conferred by the patent, then he has finished his rights in that particular patent, and he cannot extend that right indefinitely to further sale. Thank you.